This is Attorney James Ratchford, continuing my video series on the 5-step sequential evaluation process for Social Security disability. We just covered the residual functional capacity, which is what is needed to assess the claim at steps 4 and 5. So step 4 is whether the claimant can perform their past relevant work. So we're going to start with the residual functional capacity, which I just explained. That is the judge's finding as to what the person can and cannot do. And we're going to compare that against the requirements of their past relevant work and determine whether any past relevant work can be performed. If the person can perform their past relevant work, then they are not disabled. They are found not disabled at step 4, and the evaluation process ends. So first off, what is past relevant work? Past relevant work is going to be any job that you have performed in the last 15 years that you performed at the SGA, Substantial Gainful Activity level. Remember, we covered that in step 1. And that you did for long enough that you can be considered to have adequately learned the job. Any job that you really are expected to know how to do because you've done it before is going to constitute past relevant work, unless it's been so long ago, more than 15 years, that you're not really expected to remember how to do it anymore. Now, there are some kind of weird quirks here. For instance, there are some jobs that have existed in the last 15 years that don't really exist anymore, but they can still be disqualifying if you could hypothetically do it if it still existed. So there are examples of that in technology as things have changed. One example that might make sense is a job called surveillance systems monitor, which doesn't really exist in the way it used to exist because technology has changed and that job is more of a computer job than it used to be. So that's one of many examples of how a job might not really exist anymore, even though it's past relevant work. But let's not get into that. Basically, we're going to be looking at the jobs you've done in the last 15 years and evaluating whether you can do them. And so this is where we're going to start to use a person called a vocational expert in the hearing. And a vocational expert, we call it VE for short, is going to talk about your job history, your work history, and the job market, and the fit between those two, and your residual functional capacity. So what's going to happen is, in the hearing, the judge is going to say to the vocational expert, can you characterize the claimant's past relevant work? And they're going to look through your work history based on the documents that you've provided to Social Security and possibly based on any testimony that you provided during the hearing. And they're going to look at that and they're going to say, oh yes, he has 3 past jobs, he was, and then they'll give a title for that job, which comes out of the Dictionary of Occupational Titles, which is an ancient government document, last updated in the 90s, that categorizes all of the jobs in the national economy into specific titles and definitions. And so the vocational expert will give a DOT title for that job and a DOT code, which is the numerical code that classifies the job, along with an exertional level, which, as we discussed in the residual functional capacity step, is going to be sedentary, light, medium, heavy, in terms of the exertion category of that job, and then a skill level in terms of what's called an SVP, specific vocational preparation, that is a number on a scale of 1 to 8 that dictates how complicated or skillful that job is and specifically characterizes how long it takes to learn the job. So you may hear, oh, he was a cook, DOT code, made up numbers, 1, 2, 3, 4, 5, 6, 7, 8. That's not what the numbers are. And medium exertional work, SVP of 5. And that's going to be a description of your past job that is going to correlate or not correlate to your residual functional capacity based on what the judge is going to find in the final decision. And then the judge will ask what we call hypothetical questions, which are going to be, consider an individual with the following residual functional capacity, and then he'll rattle off an RFC and say, with that RFC, could the hypothetical individual perform any of the claimant's past relevant work? And that's going to be where we do this mechanical lineup process. It's just going to be a question of, in light of this functional capacity, can that person do this job? Now this is very mechanical. We're not going to typically see a lot of judgment or personal opinion going into this. It's going to be very mechanical. If your past job was light in exertion and you have a light RFC and the skill level matches up, then you're going to be able to do that past relevant work. So this is a very mechanical step. We don't really see a lot of nuance here. So it's going to be very straightforward. It's just going to be, what is your past job? And does it line up to your residual functional capacity? Where an attorney can help you here is a couple of different ways. One is in terms of categorizing your past relevant work. Some jobs are hard to categorize because they don't precisely line up to something that is in the Dictionary of Occupational Titles. Or you had job requirements in that specific job based on that employer and how that employer had you do the job, that job doesn't line up because of those particulars. And you're going to want your attorney to help you get all of that on the record so that we can make sure that we get all of the skill and exertion requirements of that job into the characterization that the vocational expert gives of it. Because if we can raise the exertion or skill level or non-exertional requirements of that job, or combine it into more than one job title from the Dictionary of Occupational Titles, that's going to help us to make it harder for a person with a hypothetical RFC to perform that job. The other thing an attorney is going to do is he's going to help you reduce your residual functional capacity. Because if your RFC lines up to your past work, then you're not going to be granted benefits. But the two ways of making that, the two ways of getting past that are either your past work is so difficult that your RFC can't do it, or your RFC is so restricted that you can't do it. So medical evidence, medical opinion evidence particularly, is going to help get you to a residual functional capacity that is incompatible with your past work. And then we move on to step 5.